So my name is Star Bobatoon. I am an attorney, a speaker, and a trainer. My background is in employment litigation, which means I handled cases in discrimination, harassment, wrongful termination, you know, all the warm fuzzy stuff. I transitioned into being a diversity counselor where I counsel Fortune 500 companies to grow their diversity and maintain their diversity while staying on the right side of the law. Here's what I really do. I remind us grown folks of the things we learned in preschool. And you help me out if you remember what they were. Keep your hands what?
To yourself.
And if you can't say anything nice?
Say anything at all.
Oh my gosh, if we grown-ups could remember those two things, I think there'd be a lot less aggravation going on in the world and certainly a lot less litigation. Oh, but I've changed that for the 21st century. Please let me know if this works for you. If you can't say anything nice, don't put it online. Yeah, does that work? I want to talk a little bit about you. See, I know something about you. Now, I've never met any of you before you walked into this room, but I know something about you. I know that you are caring and conscientious people. I know that because you are in HR. Now, some of you are saying I didn't ask to be in HR. This was not my first choice, but it doesn't matter. See, I am of the belief that either you were drawn to this position or this position was drawn to you because of who you are, because of what you have to give. See, when FMLA comes into a person's life, it means something has gone wrong. They are lost, they are confused, looking for answers, and where do they come? They come to HR, and you have the answers. When I was a new attorney and I just started working at the law firm, I was told there were 5 things that I had to do each and every time before I started any new assignment, any new client. 3 things I had to do each and every time. The first thing I had to do was read the rule. The law is very complicated, as you can imagine. There are rules for everything, so I would have to start with a good understanding of the rule. Now, once I read the rule, I could move on to the second step, and the second step was to read the rule. Now, you've done that, haven't you? Haven't you done that, Linda, where you've read the rule, you go back, you read it again, it's like a whole different thing? Well, they knew that was going to happen, so I was required to read the rule a second time. All right, so I've read it once, I've read it twice, I've got a pretty good understanding of the rule. I can finally move on to the third step, and the third step was to read the rule. Lawsuits are created by first and second level managers and supervisors. These people are saying the wrong thing, doing the wrong thing, not doing the right thing at the right time, and they are causing all kinds of havoc in your organization. Am I right? They cost organizations hundreds of thousands of dollars every single year, and they're costing you all kinds of aggravation. But here's the deal. Not their fault. It's not, because they haven't been trained, right? They were good frontline employees and they get a promotion and here's their training. It looked like this. I need you to pay attention. It's like, that's it. How many of you trained for your positions? Wait, let me stand back so I can see all your hands. Yeah, that's my point. But see, you have the authority. You have the initiative to get yourselves trained. You know what you don't know. You know what's important. You just make it happen. Your supervisors are not in the same place. They don't have the authority to get the training that they need. They don't have the initiative either. Heck, half of them don't know they don't know, right? They think, hey, you promoted me, you must think I know what I'm doing. And the ones who know they don't know, well, they don't want to let you know. See, because if you know that I don't know what I'm doing, I might lose my job. Let's move on to the A, and that is ask questions. Ask questions. And you know, I have a question for you. Whose job is it to determine whether or not an absence is FMLA qualifying. Whose job is that? Is that the doctor's job? No, it's not the doctor's job. Let me think. Is it the employee's job? No, it's not the employee's job. Whose job is it to make that determination? Oh, yeah. You know what? Let's just check the rule, shall we? Oh, look at this. In all circumstances, the employer's responsibility is to designate whether the leave is regarded as FMLA leave. It says in all circumstances. You see right there? It says the employer's responsibility is to designate whether the leave is FMLA or not. You have to make that designation. You need information. How do you get information, my friend? You ask questions, absolutely.